Good morning. It is 9 a.m. on May 29th, and this is the Colorado Energy and Carbon Management Commission. This is the second day of a three-day hearing. We will start with the roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
and Chair Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
Great. Wait, good to see everybody again. Um, as we finished up yesterday, we will start up today. This is docket 240900228, a well or location closure. We've got three parties, the cities of Dacono and the town of Frederick. We have the respondent KP Kaufman Company, and we also have the ECMC staff as a party as well. Let's go ahead and elevate the attorneys for all of the parties, and we'll get the procedural matters started.
We're elevating Mr. Sura, and I think we will have everyone at that point.
All right, I think I see Council of Record. I see Mr. Boudreau on behalf of ECMC staff. I've got Mr. Schwartzendruber and Mr. McGowan on behalf of KPK. I've got Stephen Prescott on behalf of, I can't remember, are you Dacono or Frederick, Stephen?
Dacono, thank you, Chair.
Sorry about that. And I've got Mr. Sura on behalf of the town of Frederick. Let's start with a little play of the day, procedurally, what we're going to be taking up. We've got a commissioner that has another business task at 11. So I plan on having the hearing from 9 until 10:50. We'll return at 1, and then we'll go till 5 today. We have tomorrow time set aside as well, if needed. Second on my list, the demonstrative exhibit backup documents were filed last night. I don't know if that's the right legal jargon for what they're called, but that's what I'm calling them. Mr. Prescott or Mr. Sir, did you have anything further? Thank you for the filing.
May I just have a minute to make a record on the presentation issue?
Yeah, I may offset you. The way you guys are doing it is historically how we've had folks present to us. That is, we have exhibits and then we have demonstrative exhibits that help this lay panel understand what's going on. So I'm comfortable that that is legitimate under the Administrative Procedures Act. My attorney generals have confirmed to me that our historic method of practice with lawyers works. So, having laid that sort of foundation, if you want to say anything further, Mr. Prescott, go for it.
Thank you, and I'll keep it brief. I'll just remind the commission and KPK, I know council wasn't there, but all these parties were in the financial assurance hearing for KPK. They all use presentations such as these. Those presentations are all part of the administrative record on appeal. During that hearing, if you recall, KBK introduced two new exhibits in the middle of the hearing. Dakota and Frederick attorneys were given a break to review pretty lengthy and extensive exhibits before being able to cross on them. So, we don't think we surprised anybody with the information in those presentations. They're largely from our briefings and pleadings to date, from our exhibits, or from ECMC records, which KPK also inherently has because they pertain to KPK wells. So I just want to be clear that this is standard. This is how we've always done it in front of the commission. This is how KBK has always done it in front of the commission. I understand that Mr. Schwarzenegger does not practice regularly in front of the commission, and he's choosing to go litigation style question and answer, which was an option given by the hearing officer to either go question and answer or presentation. We went presentation, so I'd like to proceed as we have and have the commission take the presentations in deliberations. Otherwise, there's no way we get through our presentation in the 2.5 hours that we did. It becomes a multi-day or multi-week presentation. There's really no other way for us to efficiently get through this. And the last thing I'll say is, like I premised the presentation with, we skipped over a lot of the information in the presentation, understanding the commission would have it for streamlining and efficiency purposes. Without the presentation in the record, we haven't created a sufficient record. So we'll have to start over.
Thank you, Mr. Prescott. Anything further from the attorneys for KPK on this issue?
Mr. Chair, we received the demonstrative exhibits yesterday afternoon for the first time. I think collectively they are hundreds of pages long. I know that they're being referred to as demonstrative exhibits, but from our perspective, they are complete written testimony, not summaries. There are snippets of exhibits that are selectively pulled when the exhibit itself hasn't been admitted into evidence in the interest of completeness. There are exhibits that have new annotations that we haven't seen. There are exhibits that have been modified to include additional information that were not in the original exhibits. And so we are actually in the process of tabulating all of that, and we will probably be submitting something in the record. I understand that we are presenting our cases differently, and they are taking a more narrative, informal approach. But I would submit to this commission that these are not truly demonstrative exhibits. And I don't think it's what was contemplated by the hearing officer, hundreds of pages of testimony. You just heard Mr. Prescott say that a good amount of the testimony that's in the exhibits wasn't even presented yesterday. And so we do have a problem with that. It sounds to me that the commission has made its order, and we will live with that. But we would like the opportunity to present objections on the specifics of these demonstrative exhibits.
Mr. Prescott, anything further?
No, nothing further. I think KBK is certainly entitled to make the objections that they see fit, and the commission has the discretion to determine what they deem admissible or not from the presentations, which I think is standard practice.
And Mr. Chair, one other comment. I guess we may, depending on what we find when we have the opportunity to fully look at these, we may ask that we be similarly given an opportunity to present KPK's testimony and excerpts of exhibits after the hearing, given kind of how this happened in the interest of fairness. So I'm not sure if that's the relief we'd be seeking, but I'd like to at least flag the issue and preserve that ability.
And the only other thing I would add on that, Mr. Chairman, is I think actually Mr. Prescott actually highlighted the very problem, right? The very problem is that he notes that they skipped over some of the information and they wouldn't be able to do it in their 5-hour presentation. So what they're attempting to do, in my opinion, and our opinion, is short circuit their time constraint, right? They put a whole bunch of information in that they hope the commission will view as fact or relevant information without actually having to present it before the commission. In effect, circumventing their 5-hour time limit by putting everything they want in their demonstrative, what they reference as demonstrative, when it's really substantive information that goes to the heart of their case, and essentially present what they feel like they can get under a 2-limit time constraint, allow more time for their cross-examination and other things without actually having to present their own case in the time that's been allotted to them. So I do think that's also problematic. If they wanted in the record, if they wanted to present it, then they should have presented it and presented it in a fashion that takes up their time and speaks to what they are trying to present, not put it all in a
All right, Mr. McGowan, I've heard enough. Okay. So understand the position from KPK. I, as one commissioner, think that the filings from last night satisfy me that the demonstrative exhibits are in fact demonstrative and can be tied back to exhibits that were in the record. Having said that, I want to make sure that all sides have a proper ability to litigate their position before us. And I'm hearing from KPK's attorneys that they do not feel they're in a adequate place to be able to do that, given the fact that the demonstrative exhibits were turned in day before yesterday. I'm happy to continue this hearing. We can stop today. I'll inform the hearings officer to find a time starting 2 weeks out that allows KPK's attorneys the opportunity to fully be apprised of the demonstrative exhibits, and we'll just take it back up. I want to get this right. I don't want to get this hurried. So I would be in favor of a motion to continue for approximately 2 weeks. I'd like us to return before the end of June because I'm going to be gone for 3 weeks starting in July, and I do not plan on taking care of ECMC business during my well-earned vacation. So with that, Mr. Schwartzengruber, what are your thoughts about that approach?
I think if we could have maybe a moment to confer with our client, but I think that that probably would be a reasonable solution to allow us to present it in a manner that is similar.
All right, let's return at 9:21. It's
Okay, thank you.
9:11. Give us just a sec. We're waiting on Commissioner Cross. There he is. All right. To the attorneys in the room that represent parties, I suggested that we have a slight continuance to allow KPK's attorneys to get up to speed with regard to the demonstrative exhibits. Mr. Schwartzendruber, you wanted a little time to talk with your client. Hopefully you've had that time and you can respond.
Yes, we have. Thank you, Mr. Chair. Yes, we are in favor, kind of given the absence of a common understanding of how we thought this was going to proceed in terms of the nature of demonstrative exhibits. We would like the opportunity to do that and continue the hearing to the week of June 16th would work best for us, and we would propose the 18th and 19th if those days are available to the commission opposing counsel.
Well, hold on just a sec. Let's hear from Mr. Prescott and/or Mr. Sura on this matter.
I'm happy to provide some brief thoughts. Obviously, we're not happy with the idea about it, about a continuance, another continuance. We were promised by KPK's counsel in February that this case would be heard by the end of April. They changed counsel, ended up needing to continue into May. We are personally shocked that KPK is shocked by the presentations and demonstratives. That said, we do believe it's necessary to ensure that everybody's having a fair hearing here. So we're not objecting to the continuance, just voicing displeasure. To the extent there's going to be a continuance, we'd like to make sure that everybody's proceeding on the same page, i.e. the presentations are part of the record and subject to specific objections to information contained therein. KPK has stated their desire to object to some of Dacono's presentation, for example. Dacono would like to preserve the same right to object to whatever KPK decides to put into their presentation, but we do believe that these are normally part of the record, and we expected that to be the case, certainly.
All right. Thank you for that. Noting the concern, Mr. Sura, you're raising your fist.
Yeah, thank you. Sorry. I don't know how that this is our problem, that the council is not familiar with a practice in front of this commission. It's been made our problem. My clients are not happy at all with this continuance. This costs us time and money. Elliot, been due to come, has taken the entire half a week off. She needs to get back to her work. Having said that, obviously we want this to be fair, and if council wasn't familiar, again, I don't think that that's our problem, but if we're going to continue this, we would ask that our PowerPoint, as is practice, gets put into the record, and we'll file it today, and that we have a week to see KP Kaufman's presentation. So we have the same benefit of being able to see the presentation ahead of time and to be able to make our any comments that we have on it or any concerns that we have with any of their slides.
All right, I've looked at, so thank you. Mr. Pedro, yes, I'm sorry. I keep forgetting your party counsel here as well.
No worries. Thank you, Mr. Chair. I just wanted to point out, I think Mr. Schwarzenegger had mentioned June 18th and 19th. And I just wanted to bring to the commission's attention that June 19th is a state holiday.
Yeah, and those dates don't actually work for commissioners. I've looked at the calendar. I've worked with Mr. Thomas, the hearings manager officer. I believe that the preferable timeframes for commission to retake this matter up would be June 9th and 10th, and reserve some time on the 11th, which is a general business agenda for any mop-up that needs to happen. If we went with those dates, then I would want KPK to provide the city and ECMC's attorneys with any demonstrative exhibits they plan on using by June 4th, close of business. That gives them a few days to get up to speed. Not that I really want to provide other opportunities, but I would like to hear an affirmative that those dates and that procedural schedule works for the attorneys. Mr. Prescott and Mr. Sura.
They do work. Presumably, I believe my witnesses are around and watching, and they can speak up if they would be unavailable on those dates. But I do know that those dates work for me.
Mr. Sura.
If I could have 5 minutes to check with my witnesses.
That's
sure we
actually
can be
fair.
available.
Why don't everybody take 5 minutes? Let's return at 9:31. Check with your witnesses.
Mr.
Really
Chair.
would like to make those dates work. So with that encouragement, we'll see you in 5 minutes.
Mr. Chair, I can actually save some trouble there. I actually have a half-day hearing that was scheduled about a month ago in another matter. I can't make the 10th work. That hearing was actually continued. It's for a case I have here in Kansas. It's a half-day hearing. It's very unlikely that the court here will continue it. I could do it later on that week, but the 10th that Tuesday is not an option for me. It really isn't. I mean, I can try to contact the court, but it is in another royalty matter that I really doubt that the court will continue in that matter. So if you could propose maybe later that week, I could probably try to make that work, but the 10th is just an option for me.
Mr. Boudreau.
Thanks, Mr. Chair. Staff just wants to point out that scheduling has been kind of an issue in this case throughout, which is why we weren't really expecting a continuance today. We thought things were going to move forward, and wondering if giving KPK the morning to review the demonstrative exhibits might be sufficient. I know that's kind of not where things are going at the moment, but staff just wanted to kind of give that input.
And then your suggestion would be to proceed.
To keep going today.
Mr. Schwarzenegger, Mr. McGowan, any thoughts on that proposed solution?
I mean, I would raise an objection to that because part of the reason we're doing this continuance is so we have the opportunity to prepare a full case inside of a demonstrative in the same manner that they did as well. So I don't think that would be sufficient at least from my perspective. I don't know what Mr. Schwarzenegger would have to say, but I would say the continuance piece would be most satisfactory. So we would at least get some time to do the same presentation manner that, they did. And again, if you want to give me like an hour, I can try to call opposing counsel in my other matter and call the court and see if I can move that hearing that I have proposed on the 9th and 10th. So if you want to give me a little time to maybe try to make that work, I can make some calls like right now and see if I can get the 10th moved, in which case then yes, it would work for me. I had to raise that because I have like a half day hearing on the 10th. That's the only objection that I'm raising to that day. And I just need to make sure that I can move it. That's be the only issue.
All right. Let's do this. I think the best thing to do is to suggest to the hearing officer that he figures out a schedule. He's got guidance from the commissioners as to what works best from us. Mr. Thomas, could you convene a scheduling conference yet later today since everybody had the time off for today for the hearing?
Yes, the hearing officer will reach out to the parties as soon as we adjourn here.
Yeah, I would say maybe like 1 o'clock. Y'all try to get together and figure it out.
Perfect.
Mr. Prescott, you raised your hand.
I was just going to propose that we finish up with John Oburn before closing this portion of the hearing. Cross has been completed. His slides came directly from his report, which was crossed, I'd say rather extensively. So we just have commissioner questions to finish that up and, shorten our return. Just a proposal.
Yeah, I frankly, I don't have a problem with that. Mr. Schwartzen, Druber.
No, Mr. Robbins, I think that this issue didn't even pertain to him, as I think he was referring to his report, which we had seen. So if there's redirect, I think they should be free to do that today if that's what the commission desires.
All right, so the hearing officer will gather the parties together this afternoon at 1 o'clock for a scheduling conference. Commissioners, I would suggest that each of you email Elias preferable dates during the time within June so that we can get this matter heard. And with that, that'll also give the attorneys time to check in with their witnesses to make sure that whatever dates are agreed upon work for all the witnesses as well. And Mr. McGowan, that also will give you time to call opposing counsel in the court to see if you can substitute out your Kansas half-day hearing.
I appreciate
All right, everybody clear as mud on all that? I see no
Thank
more
you,
raising of hands, so I think we're good. Let's bring Mr. Oburn back up. Mr. Prescott, it has been I hate to say how we generally do things, but generally we do allow redirect if you want it. I know you questioned that yesterday. It's your call. But if you have redirect, we'll let you go first. We also have a chance for commissioners to ask questions of Mr. Oburn.
Thank you, Chair. And I agree that is historically the practice. Not seeing it in the pre-hearing order, I just assumed it wasn't going to be part of this case. That said, I'm not going to do any redirect, so I'll leave it to the commissioners to ask their questions. Thank you.
Okay. All right, Mr. Oburn, I will remind you that you are under oath in this matter. You have been had a direct examination and a cross-examination. In this court, commissioners have a chance to ask you questions, and so that's where we're at this point. So, commissioners, are there questions of this witness? Commissioner Cross.
Thank you, Mr. Chair. And thank you, Mr. Ogram, for your testimony yesterday. I appreciate it, as well as preparing the report. I want to ask a couple clarifying questions based off of some of what came across in cross-examination yesterday. Big picture, there was a lot of discussion about duress. Was duress at all relevant to your overall opinion in terms of the value of the wells here?
No, was not.
Okay.
I was running just raw numbers.
Okay. And you talked a little bit about how you're not an appraiser, but appraisals are something that you do generally as part of your work. Is that correct?
I do valuations as part of my work, yes. I am not a licensed appraiser, but I do work with producing, non-producing minerals and working interests when they need to be valued. That is something that landmen typically do. One of the things that was brought up yesterday was the licensing of appraisers, the thousands of hours that are needed to be an appraiser, to put in a value on real property. And frankly, I've been in this business a long time. I don't know any appraisers that value working interest, even though they have thousands of hours of training, preparation, certification. When it comes to evaluating those types of real property interests, that's left to landmen and oil and gas professionals, not licensed appraisers.
Okay, that is helpful. And when you're doing valuations, specifically looking at wells, can you walk us through generally what kind of information you are looking at if you're not looking at the working interests?
I am looking at, if it's non-producing, I am looking at the lease history to set mineral values. I am looking at what is being offered or offered accepted via the way of letters sent to mineral owners. As for working interests, if it is producing working interest, as in this case, ECMC records are what is primarily relied upon because it's public information. It's filed by the operator. And with the production that is reported and sold, which is coming from the operator, you can, a person such as myself, can tie revenue, estimate expenses, and come up with some reasonable values of what that might be worth. Oftentimes, my clients, when I'm doing my valuation work, they also provide revenue statements to justify what they are receiving, which helps me establish cash flow. And if they have any joint interest billing or accounting that is readily available to confirm expenses, operating expenses, AFEs for work being done on wells, those are generally also provided so that basically I can take my estimates and hone them down to as close as I can to what is actually happening with the properties to come up with a better value. Because at the end of the day, you can have an engineering report. They are helpful. Oftentimes the landmen do work side by side with engineers. But when I'm in a conference room with somebody that's getting ready to buy a property, their question is, what's the cash flow? We're going to expend $1 million. How quickly are we going to recoup that $1 million? So what kind of production, what kind of revenue, what kind of expenses are going to get us to a payout of our investment? And, is it a profitable investment for us? Does it meet our criteria? That's generally the scenario I was using here. It's just I was not provided with revenue statements or actual expenses from KP Kaufman. So that required estimates. And I think my estimates are fairly well laid out explanation in my report as to how I ran my numbers.
Okay. And I do want to touch on that last part a little bit, the idea of looking through the revenue statements. I know there was a lot of discussion yesterday about JIBs, the joint interest billing statements, whether they would even exist because a lot of these are wholly owned by KPK, whether they have some of their own documents. And you just mentioned there as well that you did not receive any of these revenue statements from KP Kaufman as part of this. Do you know if you and or your attorneys requested any information like that, or were you just kind of given what you were given and kind of told to go from there?
I did not make that request. I don't know if counsel has made that request.
Okay. That's helpful as well, just to know if there possibly is other information out there or not. And you talked about some of the historical production, kind of what's going in there. Do you, in doing valuations for wells, and there was a little bit of discussion about this yesterday as well, but do you also look at comparables, both within the company that's potentially selling as well as other wells or companies, operators in the areas as well?
If they're available, I'll look at them, take it into consideration. The only comparable in this instance was the PetroShare deal that was done. And as discussed yesterday, that deal was done for $0 and the assumption of plugging liability.
Okay. And the plugging liability is something that I'm going to want to talk about in just a minute as well. But first, also going back to, there was some discussion about historical production, what's been reported, et cetera. And there was some back and forth on this as well. For example, there was some discussion where you said there was 29 out of 30 days of production in some instances, and in some instances there was no production or production for only part of the month. How do you take production that only occurs in part of the month into account? Is it just averaged out overall in what you're looking at? Do you look at if this had been producing full time, or do you look at it more so situation by situation? So, well, it was shut in because there are problems with it, therefore that production, the partial production is all right, or do you adjust based on the amount of production per month?
I don't adjust. I look at raw production to get me to a cash flow number on a historical basis. That's why I go back 3 years, because it could go up, it could go down. The well could be down for a month or two, could be down for 6 months. In some cases, these wells are down for years. Many of the wells that KP Kaufman has out here, they're only running the pump on it 1 day a month. Why they're doing it, that's their call. But what is being reported to the commission is very low production. That's what I have to work with. Um, if uh, if there is to be a higher value assigned, basically the wells need to be producing, and that's what an operator does. They'll run their wells for more than 1 day a month. And to get to what a potential buyer might look at as some sort of cash flow that makes sense to establish a value of what's there.
And how do you address situations where you mentioned that there are some where they maybe have the pump going for 1 day a month. There's also certain situations where with KP Kaufman wells, some of them have been shut in for a long amount of time because of ongoing enforcement, spill issues, remediation issues, et cetera. How do you account for the production that? Do you just simply go back the 3 years prior of production? Or do you look at if it's been shut in for 3 years for remediation purposes, there hasn't been production for 3 years?
Again, that's why I'm looking at I'm doing a 3-year look back for that reason. Hopefully an operator, if they had an issue on a flow line, if they had an issue on a mechanical, they would get their wells back up and running in a timely manner to maintain their production levels. If they don't do that, my numbers, I mean, it's going to show the well operating at a loss, simply because they have elected, for whatever reason, not to produce the well. So I don't do an upward adjustment for that reason, saying it could be worth this amount of money if they ran it 30 days a month. They didn't. And quite frankly, when a buyer is looking at a well package, they want to see cash flow. They want to see operations. And if there's mechanicals or enforcement or, loan line issues, those are all by a potential buyer factored in as a detriment and a negative to the asset. I didn't factor in negative values due to ECMC enforcement. I just used the production that was reported by KPK to try to generate some numbers that would tell somebody, are these wells right now over a 3-year period operating at a profit or at a loss?
So no assumptions to modify your valuation. Instead, the assumption is if it was valuable enough to make money, they would have spent the money to clean it up.
Correct.
Okay.
Yes, they would do what they needed to do to increase the production on the well.
Okay. And then I think the last thing that I want to talk with you about briefly is with respect to, you talked about the plugging liability. And there was some back and forth yesterday about, is the plugging liability something that goes into the valuation itself, or is it something that you look at the valuation of the well and then say maybe whatever profit from the well is then used for plugging liability later? Could you go into a little bit more detail just to clarify what your view is on how that is accounted for?
Well, I kept the two separate in my report. I was looking at operating profit or loss, and then I was looking at potential liabilities because these wells have operated at a loss for a period of time. Are they going to need to be plugged because they can no longer operate? I believe it's 8 of the 18 wells have reported zero production in over 3 years. I don't know if they can be operated. So by listing plugging information separately, that can be assigned to an overall, well, they're operating at a loss over a 3-year window. The plugging obligations are out there. They may need to plug these wells. I mean, what is in the well right now is not known by myself. It is known by KP Kaufman if they are capable of returning to production. Letha Lencioni, as she mentioned, some of these wells may not be able to be returned to production, and then you would be staring at the plugging liability, which was set aside separately in my report.
So unlike, and just to kind of put the finishing touches on that, unlike Miss Lencioni, you're not saying part of the overall value of the well is if they get it running, you're also going to have costs, the field cost, the operating cost of well by well, as well as potential remediation and plugging costs. You're just saying, just numbers wise, here's what the values of the wells are.
Yes.
Okay. I think that's my only questions. Thank you for the clarifications. I appreciate it.
Thank you, Commissioner Cross.
Thanks, Commissioner Cross. Other commissioners with questions for the witness? All right, I'm seeing no further questions. Mr. Oborn, you were relieved. Thank you very much for your appearance.
Thank you, Commissioner Robbins. Have a good day.
All right. With that, we've concluded, I think, the business for today. A couple of just cleanup matters. The matter is going to be continued. We don't have a date, and the parties will meet with the hearings officer at 1 today to determine appropriate dates during the month of June. Those dates need to be out there far enough to give KPK an opportunity to get up to speed. If KPK, between now and the continuance, there will be no additional evidence admitted. So all parties be cognizant of that fact. If KPK desires to put together a demonstrative exhibit and or present in presentation style, that's fine. I would want that demonstrative exhibit shared to the attorneys for the cities in a timely fashion so that they're not caught in the same position that KPK alleges it has been caught. I think that covers it. Hearings Manager Thomas, AAG Davenport, did I miss anything?
Not in my view, Chair.
Okay. And then Hearings Manager Thomas, I believe you wanted to inform the world that we're going to have a special meeting at 1 o'clock tomorrow. Do you want to talk to us about that? This has nothing to do with the current matter, so just hold on just a sec.
Yes, thank you, Mr. Chair. Unrelated to this matter, staff has asked me to request that the commission not vacate tomorrow in full and reserve 1 p.m. to 2 p.m. for a potential emergency matter. We'll get the agenda updated accordingly for that this morning.
Okay, and that doesn't involve the docket that we're dealing with right now. That's something new.
Correct.
Okay, final thoughts from attorneys. Mr. Surrey, you've got your hand raised.
Yeah, thank you for recognizing me. When we had this discussion and first discussed the possibility of continuance, we were okay with doing that so long as has been the past practice, our presentation would be part of the record, and okay with having KPK put that in the record as well. That's just the way that it has been in all the hearings that I've been a part of. And in fact, there's a tab that allows you to put in hearing exhibits into the record. Because that's been past practice, and because now they have plenty of time to view those new exhibits, I think that's what we ask from you as part of this order.
And the ask is not that the demonstrative exhibit turn into an actual exhibit, but just that it be something that commissioners look at when they're deliberating on this matter.
No, I'd like to actually be put in as an exhibit into the record.
Okay, Mr. Schwarzenegger.
Yeah, thank you. So I think the way we had proceeded in pre-hearing procedure was that we got actual exhibits and we submitted objections to them. And so I think, I think we're fine proceeding on the understanding that the demonstrative exhibits should be admitted or should be part of what the commission takes back during deliberations. But I do think that the parties should have the ability then to do as we did with the exhibits themselves, is potentially submit objections. And the only reason I say that is I believe that in some instances exhibits have been modified a bit. And so we'd like to point that out. The only other thing I was going to say, Mr. Chair, is we would also like to see staff's demonstrative exhibits on the same deadline as ours. But that would be, I think, the only request we'd make on that.
Mr. Boudreau, any concerns about that?
Staff does not intend to present demonstrative exhibits.
All
Our
right.
only exhibits are the exhibits listed on our exhibit list, and they're all publicly available and in coaches.
Okay, great. All right,
Well-
then the demonstrative exhibits will be made a part of the record as exhibits, subject to objections from parties going both ways as to the demonstrative exhibits. Okay with that, Mr. Sarah?
Sounds great.
Mr. Schwarzenegger?
Yes, thank you, Mr. Chair.
Mr. Chair, I would like one clarification. You did note that no new additional exhibits or information would be submitted. The only
Except for any demonstrative exhibits that y'all are planning on putting together between now and the timely submission of those to the other side. That's allowed.
appreciate that. Thank you, sir.
Those demonstrative exhibits need to be based upon exhibits that are already in the record, obviously.
Nope, gotcha. That's fair. That's all I wanted clarification. Thank you. Appreciate that.
All right. Anything further from the attorneys in the room? All right, seeing none, we will continue docket 2409-00228, consistent with all of the machinations that we've talked about over the last hour and a half. And we encourage the parties to get together with the hearing officer at 1 today. And this commission will return tomorrow at 1 p.m. for an emergency docket. With that, I would move to adjourn.
Second.
Motion and a second. All those in favor signify by saying aye. Aye. Any opposed? We're adjourned. Thanks, everybody.